global happenings today. We communicate, we analyze global news. Stay tuned.
Hello beautiful people, welcome back to our channel. We have a very serious case right now. Some few days back, in fact some few hours ago, Peter Obi came online, spoke about what happened to his brother's property, a property located somewhere in GRA Ikeja, Lagos. It was a company probably owned by the brother or jointly owned. You are going to get the full details of that in this video as you keep listening. Now, he said a lot of things. It was demolished, and those who came to demolish it came with a court order, and there it showed a nameless and unknown person was what the courts filed to demolish a property of an unknown person, and there was no court order or demolition permit for them to demolish the property. A lot of that, of course, Peter Obi went online, made it viral. Nigerians reacted. Of course, someone told Peter Obi to go ahead and lodge his matter or his case to the nearest police. Well, the matter have taken a different turn entirely, and there's a drama playing out. Now, the claimant, those who are involved, the lawyer of the claimant have come out, being that Peter Obi is now involved. She has given the full detail of what happened before now and the original owners of the property. Now, the brother of Peter Obi's lawyer have also come and given the drama that played out just June 20th. And you are going to get to hear how this whole matter started and how Sanwo-Olu is involved. Let's dive into the news proper. Obi condemned what he described as Nigerians' descent into lawlessness under President Bola Tinubu, citing the alleged illegal demolition of the property as an example. Court documents and a certificate of occupants identify one Mrs. Deborah Oluwalogbon as the rightful owner of the property in Lagos State, which Labour Party presidential candidate in the 2023 elections, Peter Obi, claimed belonged to his younger brother. Obi condemned what he described as Nigerians' descent into lawlessness, and he said that the worsening state of human rights in the country has left ordinary citizens, small businesses, and vulnerable groups increasingly exposed to systemic abuse and insecurity. In a statement which he said in his social media handle on Tuesday, he expressed outrage over the incident, which he said reflects a broader pattern of impunity and disregard for rule of law in the country. Now, this morning, my youngest brother called me frantically, informing me that a group of people had invaded his company property in Ikeja, Lagos, and were demolishing the property. The post read, he has just come in from Port Harcourt and was denied entry into the property by some security men. Now, on arrival, he said he was confronted by security personnel who barred him from accessing the demolished building, but he appealed to them, insisting that the property had been his brother's for over a decade. Now, document shows court granted ownership to Oluwalogbon. However, there's some document obtained by Sahara reporters showing a court judgment that granted ownership of the property located at number 57 Oduduwa Crescent in the Ikeja government reserved area, that's GRA of Lagos, to one Mrs. Deborah Oluwalogbon. That's Oluwalogbon. Now, this followed a suit with number ID/4378LM/2023 instituted by Oluwalogbon before the High Court of Lagos State. A further check on the document showed that while Oluwalogbon was listed as the claimant in the case, the defendant was listed as an unknown person. The High Court of Lagos Ikeja Division ruling delivered on May 24, 2024. I tell that again. The High Court of Lagos Ikeja Division ruling delivered on May 24, 2024 reads that the claimant filed the suit on June 6, 2023 to claim property of 57 Oduduwa Crescent Ikeja on the ground that those in possession are squatting and are in possession without the consent or the contract of the claimant. Now, the originating processes and hearing notice were served on the defendant by pasting at the gate of the premises by Tony Awolose, a sheriff of this court, on October 6, 2023 and April 22nd, 2024 at about 11:05 and 10 a.m. respectively. And despite these services, the defendant did not attend court and did not file processes to deny the claim of the claimant. Now, the implication of this is that the defendant is taken to have admitted the fact of the claimant and is also taken to have conceded to the relief asked for by the claimant. Consequently, the request of the claimant is granted. The possession of 57 Oduduwa Crescent is granted in favor of the claimant. Cost summarily assessed as 2 million naira is also granted in favor of the claimant against the defendant, the ruling acts. Additionally, a police report indicated that the land was initially allocated to Mrs. Oluwalogbon by the federal government in 2003. A certificate of occupancy signed by Governor Babajide Sanwo-Olu was issued to her on February 17, 2025. Oluwalogbon's lawyer accuses Obi of politicizing the dispute. Now, speaking to reporters, a lawyer on Mrs. Oluwalogbon's legal team, Mayomi Afeke, faulted the post by Obi. He said, in one breath, Mr. Obi claimed the property in question belongs to his family. In another, he said it belongs to his brother, whose identity remains conveniently hidden. At yet another point, he suggested the property is owned by a company where his brother works. So which is it? The truth is becoming increasingly clear. Mr. Peter Obi has no real connection to this property. Rather, he appears to have been hired to use his influence, his name, and social media reach to politicize and sensationalize a matter that is currently before a court of law. Nigeria is not a lawless nation. It is people like Peter Obi who ought to know better, who encourage lawlessness by attempting to sway public opinion against lawful judicial processes. If Mr. Obi was genuinely interested in justice, he would have presented a balanced view of the situation instead of using social media as a courtroom to push one-sided narratives. He knows fully well that the suit number of the case in which Mrs. Olorunlogbo's secured judgment is boldly displayed on the property. The party he is fronting for has already joined issues in court. For the record, Mrs. Olorunlogbo possesses a valid judgment, certificate of occupancy, and other official documents confirming her ownership of the property. Until a court says otherwise, the property is hers and to use as she sees fit. The disturbing pattern here is that Mr. Peter Obi's current online campaign is a continuation of earlier disobedience to court orders orchestrated by his associate. The matter was duly reported to Zone 2 Police Headquarters in Lagos. They were invited for questioning, a fact Mr. Peter Obi himself has acknowledged, but they chose to ignore the police. Now, Mr. Obi has taken the dangerous route of self-help and media trial, which undermines the rule of law. Under the Land Use Act of 1978, Section 28, any revocation of land rights requires a clear public interest justification accompanied by notice and compensation with dispute adjudicated in court. The Constitution of the Federal Republic of Nigeria 1999, Section 44 safeguards property rights against arbitrary deprivation, but the protection hinges on legal proof of ownership. For a suit against unknown persons, Nigerian High Court rules mandate presenting original titles and certificate true copies, that CTCs, from the land registry, along with multiple notifications, often repeated up to 4 times of quarterly intervals, to ensure all parties are aware. Now, this process takes 6 months to a year, gives ample opportunity for Obi or his relative to counter claims which authenticated documents. Yet, Obi's post provides no evidence of these legal steps or his brother's ownership documents, casting doubt on his narrative. Instead of seeking a stay of execution, a remedy a court could grant within a week, if satisfied with the valid document, Obi opted to appeal to public sympathy. This bypasses due process, as noted in earlier discussions, where the expectations was for him to engage the court rather than a court of public opinion. The public has no basis to judge without hearing the other side, especially when Obi's story lacks verifiable proof and ignores the legal notification allegedly posted. If the party Mr. Obi represents truly believes it owns the property, let them bring forward their documents and make their case in court. That is how civil disputes are resolved, not through online grandstanding and emotional manipulation. Obi's action risks undermining Nigeria's legal system, and this must be condemned. My goodness. Okay, but then again, however, Emeka Okpoko, a senior advocate of Nigeria and a lawyer representing the Nest Foods Limited, which is claiming ownership of the demolished property, said he became aware of the case on Friday, June 20th, after some persons came to effect possession. He now said in 2021, UK authorities struck off Nest International UK Limited, a company largely owned by Peter Obi, for failing to file its annual account. Obi's brother, Ndibe Obi, serves as the chairman of Nest International Nigeria. Now, report has it that, according to the Sahara reporters, said they were unable to verify the names of the directors of its subsidiary Nest Food Limited on the Corporate Affairs Commission (CAC) website, as the site was not functioning properly at the time of the check. However, open source platforms such as NetCheck and the rest listed both Peter Obi and his brother Ndibe as directors of Nest Food Limited. Due to the CAC website issues, Sahara reporters could not independently confirm from official records whether Obi still has any link to the company. Peter Obi, for his part, has consistently insisted that he no longer involved in any businesses connected to Nest. Now, just this last Friday, June 20th, we were called upon that some people came here to take possession. We never knew that about dependency of any suit at all. The suit was filed against persons unknown, and the lawyer he said that what we did was to quickly go to the registry to see the process filed. That is which process they relied upon to come to this place. We got it only to discover that they came by originating summons, and they are even claiming possession, not claiming ownership. We then made copies of all these processes and walked all through Friday, and on Monday we filed our application, which was yesterday, June 23rd, for a joiner. That is, let us be joined in the case as parties, and we attach affidavits which we annexed copies of materials, documents showing that we truly own this house. We attach the deeds of assignment, attach the certificate of occupants, every document to show that we genuinely own the house. We also filed a separate application seeking to set aside that order of the court, because the order was obtained without the court knowing that other persons owned the property, because they just sued an unknown person. I can assure you that if you go through the evidence of service, what they did, they will paste a court process, snap it, remove it, and go back to the court to file evidence that they have affected service. We attached all these things in our application seeking to set aside that judgment. We also filed an application setting aside further execution. We have an injunction pending the hearing of the suit. We also have a prayer which we are asking the court to convert the case to pleadings, so that everybody will file their own side of the story, and the court will take a plenary session and hear